The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 5 cases will be submitted this afternoon. They are Monroe Branstad versus State of Iowa Department of Natural Resource Commission and Department of Natural Resources. Iowa Supreme Court Attorney Disciplinary Board versus Heather Kingery. Derek Crow versus Edwin E. Simpson and others. City of Davenport versus Laura Paulson. And the last case is in the detention of Ben Sanders. The last 3 cases will be submitted without argument, and we'll now hear the arguments in the Branstad case. Mr. Thompson.
Thank you, Chief Justice. May it please the court, counsel. This dispute arose in August of 2008 with the discharge of pollutants into the Winnebago River and the resulting fish kill. The discharge and the violation has never been disputed. The causation of the kill and the number of fish killed and the resulting restitution assessment have been the fighting issue between the parties for years. What's before you today is an application, an appeal arising from an application for attorney's fees under Chapter 625-29 that arose after a district court affirmed the causation and the liability portion of the assessment, but reduced the amount of the assessment based on its conclusion that the DNR had applied a faulty fish count method. The district court denied the application, finding that 3 exceptions under the act applied to the request, and then on review of that order, the Court of Appeals reversed, finding that in this case that the exceptions did not apply and that the Branstad applicant was a prevailing party. Before you today is a very narrow issue that we brought on further review, which relates to one of those exceptions. It's the exception under 625-29-1B that says that an agency of the state cannot be subject to a claim for attorney's fees if their role is primarily adjudicative. We believe that the Court of Appeals, that the district court got it right, and that the Court of Appeals got it wrong really in 2 important ways. One is the Court of Appeals failed to apply and therefore reached a conclusion inconsistent with this court's case in Reamer, 1998 case, and that legal error was really caused by an analytical error or a structural error in the way that the court analyzed the process that led.
Can you give me an example, because I'm having a hard time, of when their role would not be adjudicative when the department who brings the charges hears the charges, under your analysis?
When the department who brings the charges hears the charges.
Actually determines the validity of the charges.
In a contested case?
A contested case. When would they not be an adjudicative body?
I don't think there's a situation where they would not be an adjudicative. Again, there are 2 important exceptions here, and we're talking about not the one, there's 1D that is expressly for adjudicative roles, where the state is simply adjudicating separate parties' interests. B is one that acknowledges that the state often will play a mixed role, where the state will have an enforcement, a policy reason to do investigations, and then maybe the final deciding agency.
How would they ever not be the final decider when they bring the charges if it's prosecuted or adjudicated through the agency? I mean, it seems that that exception will never exist. If we make it very broad, like I guess Reamer did that, but if we continue to follow Reamer, it becomes very, very broad, and it's sort of like the rule will never be applied unless you can tell me when it would be.
Well, I believe, I think our position is that in a procedure like you see in this case, or like in Reamer, that follows the current Administrative Procedures Act framework in Iowa, which grants a contested case in a virtually all situations that would be required by the Constitution, that where the agency action that's being challenged, and this is important, is that final decision based on a contested case that determines the rights and the duties of an individual based on their conduct, that will always be primarily adjudicative.
Can you determine, again, I want to go back to my first question. Okay. Can you think of a situation when that wouldn't happen?
Not when there's a contested case and the final decision maker is the agency from which that contested case arises.
I was grappling with the same question that Justice Wiggins was grappling with, because I think that concurrence by Justice Carter and Reamer gives us all concern that this thing can't swallow all of 17A. It struck me that a declaratory order might be a situation where the state's role would not be primarily adjudicative, yet it would still arise under 17A, and that might give some role to the 62529 without having the B exception swallow all the 17A scenarios. Is that true?
I think that's true, and I think there are other examples. The question that I was responding to was a scenario where the procedure in place provides for a contested case and a final decision based on a contested case. I think that is always going to be primarily adjudicative. But that isn't all that happens. I mean, there is, as Mansfield says, we've got these three categories. We have rulemaking, we have formal adjudication, but then we have other agency action. And in other agency action, there, as Mansfield and the Remmer case recognizes, there can be informal adjudication that goes on in there. But there are all other things that go on that would be subject to 17A judicial review. The Polk County versus State Appeal Board case is a good example. The court said no contested case, but there is a right to judicial review. And so it's, you know, the question there is, that's not a contested case. Could that be subject to attorney's fees? I think that's an example. Perhaps the best example would be where after a contested case, the agency takes action to enforce an order or to do something that enforces rights against parties where there is no contested case process, and that those would be subject to 17A and subject to 62529.
The problem we're grappling with is there must be, if we follow normal rules of statutory construction, there must be some category of cases where it's an action for judicial review brought against the state pursuant to Chapter 17A. It's not a rulemaking because that's carved out.
Correct.
And yet it isn't, the role of the state is not primarily adjudicative. So there needs to be some content to that category if we follow normal rules of statutory construction.
Well, it would, and I'm saying that you're going to find those types of actions in other agency action. By definition, that the contested case category is adjudicative. I mean, you read the man that drafted the Administrative Procedures Act, he says that's what it's for. But I want to go back to the rules of construction, because that's one of the things here where we've kind of got this blind application or an argument that we should blindly apply it. That's where the Thulman article is kind of instructive, is that this is intended to be not an exception to a broader rule. This is intended to squeeze the remedy very tightly here. And if you look at the legislative history that's recited in that law review article, there were 2 or 3 attempts that were broad loser pay type applications. They were all rejected. It was only after these exceptions, these exclusions were added to the statute that the bill was even passed by the legislature, and that there are other mechanisms in there. The reality is the way that our administrative law has developed in Iowa. The right to a contested case has become almost universal. That was one of the key issues, if you look at the reform in the 70s and then the passage of this bill in the 80s, was to provide a mechanism outside of court for parties to fight off state action. And this bill that gives them action if they are brought into court by the state or end up in district court and prevail against the state, narrow way to give them a remedy. But the Administrative Procedures Act creates layers upon layers of due process here, and it's exactly that achieves a lot of the purpose of this deterrent against state agency overreach. And I think that other agency action is the key here. I think that the other thing that's real important here is the structural problem of embedded in Justice Wiggins' question, I think, and I think yours as well, Justice Mansfield, is who are we talking about? Or what role, we have to look under 17A at the actual agency action that is before the court. It's a jurisdictional issue. Here, I mean, the final agency action that was appealed from is an action by the Natural Resources Commission. And if you look at the statute, 455A, this is an entity created for the sole purpose of writing rules and guidance and oversight for administration, but specifically to conduct the appeals that arise from contested cases on these specific statutes. And so under that statutory scheme, the Department of Natural Resources has been delegated the investigatory role and the prosecutorial role, but the issue on appeal on the judicial review was the final agency action, which was the commission's order. The commission, in all respects, with regard to this case, was acting in a adjudicatory way. In the sense that it promulgates rules and it delegated authority, it has an administrative role, but the order that's before this court, or that was before the district court when it denied the fee request, was an order from the NRC sitting in an appellate capacity, and that's the final agency action that was before the district court in the first instance.
Before your time runs out, can you talk about the other two exceptions? I know you argued about them in your brief. You still think the other two exceptions apply?
Well, yes, but I mean, on further review, we've really focused on the primarily adjudicatory. I think that the special circumstances is very fact specific. This is a case that, in part, because of the way that the outcome was, that one could order there's an unjust outcome here. I think the strongest argument, if we get beyond the issue that we raised on further review, to be frank, is whether whether Branstad was a prevailing party at all. I mean, the cases that get cited for that proposition are federal civil rights cases where a plaintiff can always recover against a defendant if they recover on a single claim and a number of claims that they bring.
But counsel, wouldn't most lawyers who achieved a result of reducing a fine of over $60,000 down to $5,000 put that in the win category? Wouldn't that mean you're a prevailing party?
I think it's a win. I don't think it makes you a prevailing party under the statute, which is why in an employment case, if we fight for 5 years in a multi-million-dollar case and as a defendant and we win, we're not the prevailing party. We're not entitled to fees under any framework. And in this case, Monty Branstad was the defendant. And so prevailed only in the sense that he reduced a fine or an assessment for a violation and causation that was upheld on appeal.
Did he also change the department's practice on how to count fish kills?
I don't know that he changed it. The rule was the same, and what the requirement was, what he established, or at least the district court thought he established, is they hadn't followed their own rule in this case. But again, this is guidance that was, we've got a layer of a rule and a reg, but yes, they found that the counting methodology was not compliant with the rules.
I think the Court of Appeals, I think I recall a statement in the Court of Appeals opinion to the effect that DNR is now changing its practices on what it does when there's a fish kill and how it counts the fish. Is that true? I didn't see any that indicated one way or not in the record. Is that correct?
I don't know, other than, I mean, as I
What
understand
does
the
the
court's
record show?
order is, the court said you need to follow the law, and I imagine DNR will follow the law in accordance with that order.
What about the distinctions that have been raised with the Reamer case? It's been suggested that, well, here we've got DNR, and then we have the commission, that's different from Reamer, because Reamer was the Board of Medical Examiners kind of all along, if you will. The argument, as I understood it, was that because you have multiple state agencies, that might have impact.
I think, I'm sorry. I think they do try to draw those factual distinctions. I mean, I would argue, number one, it doesn't cut to the fundamental issue in Reamer, which is whether the rights of parties were adjudicated or not. But I think those factual distinctions would permit us to argue that, frankly, this case, in this case, certainly the NRC was more adjudicative than the Board of Medicine, who handled it in Reamer from beginning to end. Here, we've got a statutory scheme with a final decision maker that delegates investigation and initial assessment and negotiation of voluntary settlements to one party, and then is the party that comes in to hear the appeals when a citizen complains. And so, if anything, the final order here is more adjudicatory in nature, and I think that it does not permit this court or the Court of Appeals to ignore the guidance in Reamer.
I think in a way they may be attacking the DNR. I mean, they're saying DNR arguably, I mean, DNR did an investigation and came
True.
up with their calculation.
I think that's right.
Then we have a hearing officer, and then finally the NRC. Is there? Can you somehow sever the DNR, the investigative function from the DNR from the adjudicative function of the commission?
Well, I don't think the statutory scheme severs it. I mean, it's delegated under the way the statute breaks up the roles. But I do think that the fact that again, we're in 17A, and the issue that the courts have jurisdiction over is the final agency action, which is the NRC's decision, purely adjudicatory, and that the DNR's preliminary investigation and preliminary assessment that leads to this, if not appealed, would not have been something you could bring 17A on, and when it's appealed to exhaust the remedies, then you get a contested case and another decision maker. I mean, it's designed to put in safeguards and due process for somebody who disputes an underlying assessment. And I'm out of time, unless somebody has another question. Thank you.
Thank you, Mr. Thompson. Ms. Branstad.
Thank you, Your Honor. May it please the court, counsel. Let me first address the question posed by Justice Apple. The difference between primarily adjudicative and primarily litigative in this case is illustrated by the difference in the structure, even the physical structure of these hearings. In the fact-finding hearing involving Dr. Reamer, the Board of Medicine sat at the front of the room while the Attorney General was at one counsel table and Dr. Reamer and his attorney were at another, presenting to the board. On the contrary, in Monroe Branstad's hearing, it was an impartial ALJ, an administrative law judge at the front, while the DNR was represented by the same attorney who represents the NRC, and Mr. Branstad and his counsel were at the opposite table. Even if you look at just the simple structure of how that was presented, that visual representation is emblematic of the nature of those actions.
Well, but let me ask you, you're factually correct, as I understand it. I mean, you had a neutral hearing officer from Department of Inspections and Appeals. But that hearing officer prepares a proposed decision that goes to the NRC. The purpose of the hearing officer, it seems to me, is, to have a structured hearing and gather the evidence. It's awkward to have a multi-party or multi-member commission take evidence and so forth. So the hearing officer assembles the record and then serves it up to the NRC. So I'm having a little difficulty seeing the distinction between that and functionally at least, between that and what happened in the Reamer case.
Well, certainly the difference is as different as presenting at the district court and having an appeal heard. There's a lot of deference that is given to the person who sees the demeanor of the witnesses, hears the cross-examination, and really makes those fact-finding determinations. And in another more practical sense, in Reamer, the Board of Medicine had nothing to gain or lose at the hearing. If a good doctor stays in Iowa, that's good for Iowa. If a bad doctor is gone, that's good for Iowa. In this case, the DNR had money to gain or lose. There was a $60,000 plus fine.
But I think, follow up on Justice Apple's question, Ms. Branstad. I mean, the statute, the exception says the state's role was primarily adjudicative. So what we evaluate is the state's role. And it seems to me in the Board of Medicine scenario, the Board of Medicine wears all the hats. Here you have the DNR, you have the DIA, and you have the NRC all involved. But they're all part of the state. So what's really the difference between the two cases?
If you take out every case that's heard by an administrative law judge or by any employee of the state, I think that leaves only cases involving a federal court suit involving a non-administrative action. I mean, it would only.
And I'm bothered by that too. But then what about Mr. Thompson's point that there are other agency actions other than contested cases in rulemaking that are out there, where if you had a battle with an agency, for example, over a declaratory order, you didn't like what the agency did, so you then asked for judicial review under 17A and 1, that might be a case where you could recover attorney's fees because the state's role was not primarily adjudicative. Isn't that possible?
Well, first of all, in a declaratory order case, I think the petitioner asks the agency to provide their view of the law on assumed facts. And when we're looking at an act that's called the Equal Access to Justice Act, it really eliminates most real plaintiffs. And when this act was enacted, it was enacted in order to allow a remedy and an access to justice for individuals and small businesses that were at conflict with agencies. That, I think, would place it in such a limited role. And it was such a limited role that in oral arguments in front of the Court of Appeals, the state's attorney and the Court of Appeals judges specifically stated they couldn't think of any actions, I think, where under this interpretation, the Equal Access to Justice Act would provide attorney's fees and access to justice. It appears that this is exactly the sort of case that the act is aimed at. You have an individual against whom a fine was levied. Unlike the Reamer case, the fine was just levied. Branstad initiated this action by appealing that fine. And if you look at...
Well, you appealed on causation too, as Mr. Thompson has indicated. Is that not right? I mean, that was one of the issues.
That was one of the issues.
All right,
initially.
And you did not prevail on the causation issue, I take it. But you did get substantial relief on the fine.
Yes.
Okay.
And by the time that this matter was at the district court level, really the fine was the main thing that was argued, and even at the agency level, in discussing causation, the main questions were aimed at, did the counting methodology take into consideration the other possible causation, that it was following a heavy rainfall? It also took into account the structure of the counting and the methodology.
When I look at this decision, it seems to me that the decision of the agency was supported by substantial evidence. Number one, the fish were killed, caused by the runoff from the manure pit. Number two, that there were some damages, and the only thing the court ended up doing, or the agency, whoever did at the end, I can't recall right now, was to say you applied the regulation wrong. I mean, so it really wasn't a substantial evidence question. It was an application of law to facts, and if you read the McIntyre case, it seems to me that may cause you problems too in getting a result, because there's no question the fish were killed, there's no question there were damages, there's no question they were caused by it, or at least substantial evidence supporting it. It was just, what is the formula for damages? And that comes up all the time. Like in a loss of profits case, we have different rules and different things, and it just seems like it was applying the law wrong, not that the evidence didn't support the verdict.
Well, no, I believe that I would take issue with that the real question was about the counting and the amount of, and the fish kill counting. Branstad entered a consent decree stating that there had been a leak from the silage, and in fact was helpful in the investigation. That wasn't in question. The question was there the level of fish kill? And although there were alternate theories provided, the briefs, the questions all really centered on that counting. And I think if you say that any time an alternate theory fails, then you're not a prevailing party or there's not substantial evidence, you run the risk of, again, putting in exceptions that swallow the rule. In this case, as I said, there was a consent decree, and the real argument was about the fish kill. That was almost all of the exhibits went to what was the level of the fish kill and was the counting accurate. And that's, again, that's specific to this case, but dealing with the argument about whether or not this procedure was different than the Reamer case, certainly in this case, the state picked this fight. The state issued the fine. The state was, through the DNR, a separate actor and at a different table. And let me just step back. One of the questions...
Well, you keep saying a separate actor, but if you read the Board of Medical Examiners rules, and I haven't been practicing for 10 or 15 years, but they have a separation too. Now, they're called the Board of Medical Examiners, but they break the board up into the accusatory ones and the adjudicate ones when you read their rules. So they're really two separate entities that are bringing the case. And I'm not sure when Reamer that was in effect. But when I practiced law and appeared before them, they always had different members of the board do the accusations and then different members of the board do the adjudication in order to avoid the problem. So it seems to be similar.
In this case, it was an administrative law judge who was...
But you didn't appeal the administrative law judge decision to the court because it's not appealable, because the final decision comes from the agency, not from the administrative law judge.
And if that is the interpretation, then it would seem that any agency action, we're back in the same position where almost any agency action, there would be no remedy because...
I agree with you. That's the problem I have. But to make these fine distinctions, I don't think get around the problem whether Reamer is too broad or too broad and creates no room for you to win once in a while.
And it wouldn't make sense that the legislature specifically references 17A actions, but then creates an exception that eliminates all 17A actions. And really, I mean, the code section specifically references 17A actions. if it doesn't apply to cases where fines are levied against individuals and businesses, it
Well,
really
it's not a matter
has-
of fines, it's a contested case. I think the state's position, if I understand it correctly, is, I mean, if you look at 17A, you know, the head notes of 17A, there'll be a section for contested cases and it'll kind of run on. But then there'll be other agency action, a much smaller category, but it says other agency action. So if you're looking at the annotation, 17A, other agency actions, there'll be a bunch of cases there. In those cases, other agency action, if the state's position is not supported by substantial fact, they can get hit for attorney's fees. But where there's a contested case, at least, the state suggests that the statute doesn't allow it because it's under Reamer, because it's, quote, primarily adjudicative. So, you know, it may not be the hugest category of cases, but there, you know, there's a couple dozen other agency action reported cases, or maybe more.
I think that takes the common sense out of the legislation then, because if the legislature only intended that to apply to other agency action, I think it would be titled,
Could have said it, couldn't they have?
it would have been titled as such.
One of the problems with adopting your position, and my troublesome position, is that you're going to penalize the agency when they act as an adjudicator and come up with the wrong decision. I mean, I don't think I'd like to be a judge, and when I'm wrong, I got to pay because I got the wrong decision. And I could see that purpose for the legislature to do it in that situation where it is adjudicating a right in a contested case.
Well, that was essentially the argument made by the state at the Court of Appeals was, under this interpretation, DNR officers will have to think twice before issuing fines. And I'm not opposed to officers thinking twice.
I don't think they have to think twice issuing fines, but the DNR, when they adjudicate it, better think twice before they do it, because if they get it wrong, not only can their decision be appealed, but the adjudicator is responsible for the attorney fees of the litigant, and that sort of bothers me.
Well, someone is going to have to pay the attorney's fees to litigate. And if an agency has not followed their own rules, not followed their own practices, and created an unfair situation, it seems like it makes more sense for that agency to pay for the attorney's fees than for the individual or small business who were essentially
Would you say the
victimized by
same of
that.
a judge in a district court who got it wrong? They should pay the loser's attorney fees?
This falls upon the person who brings the action to bring an action that's supported. It isn't on the judge, it's on the entity that brings this action. In this case, this action was instituted by DNR. It was absolutely started by DNR, who had the obligation to follow their own rules and to know the law that they were under. It's not the judge who needs to pay for this, it's the Department of Natural Resources who instituted this action and who prosecuted this action.
Isn't that all true in Reamer?
There was no action against Judge Reamer. I mean, in that case, there was an investigation, but in that case, it was still, at that point, being presented to the Board of Medical Examiners. And there's a little difference, again, that there was no stake for the Board of Medical Examiners in winning or losing at that evidentiary hearing. Whereas in this case, the DNR had $60,000 to gain or lose.
The Board of Medical Examiners had a stake to protect the citizens of the state of Iowa from bad or good medical care. I don't see how they didn't have a stake.
But isn't their stake isn't in winning or losing, in finding for or against Dr. Reamer, it's just in finding the right decision. There's a different stake there. And I see I'm out of time. Thank you.
Thank you as well. Rebuttal?
Your Honor, very briefly. I just want to go back for a moment to the DNR issue. Again, the Court of Appeals' fundamental error, I believe, was the sentence that says, so we focus on the DNR and the role of the DNR. DNR is not the final decision maker here. The statutory scheme permits them to start the process. We concede that. But the legislature created a scheme where if somebody doesn't agree, the rules say you've got to try a voluntary resolution. If there's a dispute, they get a contested case. And what that does is it substitutes. Somebody else comes in and is the decision maker, the NRC. And in this case, as most agencies do on contested cases, the NRC delegated the fact-finding hearing officer role to the DIA, ALJ. That's what people do. But the decision maker is the NRC here, not the DNR. And so all these arguments about DNR miss the point that they're not even before you. That's not the final agency decision that's here. And so structurally, this point of having this opportunity to object without going to court to an agency's action and invoke the right to a contested case was the goal of the Administrative Procedures Act, to give people protection, and it does that. And to then say that that now is subject to attorney's fees, I think walks it backwards. The other thing is that's very important, I think, and again, this is the interpretation issue, and it's easy to get focused on this statute. I mean, it says what it says. This court has interpreted adjudicative in the past, and this court has decided what that means and has done so almost verbatim consistent with author Bonfield's definition of what it is for purposes of administrative law. I mean, that's the definition as a matter of law, and that this court should follow that and apply it. But in the context of this 1983 Equal Access to Justice Act, I want to again reiterate that it, by definition, is in itself an exception to the general rule. The general rule in the United States is not loser pays. So they carved out a narrow exception to the general rule. And it's a hard, I mean, even the law review article that is cited by Branstad, if you read it to the end, what they say is, well, they passed a law and virtually nobody is going to be able to recover under it. You need to change the law. And that's how they read it when it was passed.
Could you help me understand how the substantial evidence exception would apply? What issue does that relate to? The number of fish killed, or the methodology of counting fish, or something else?
I think substantial evidence here applies obviously to causation, number one, and number two, to the fact of the kill and the position taken by the state. Again, this is so that the state isn't making frivolous arguments. Substantial evidence supported the state's position that they took. What the court concluded is your position was based on an erroneous interpretation or application of the law. And so it wasn't that they had to follow a certain methodology and then just didn't have any facts to back it up. They had facts to support their position. It's just that the legal conclusion was you didn't apply the right standard. What one could argue that they should have just remanded and go apply the right standard and let's see what the amount is. But that never got appealed. What's up here is the Attorney General. I mean the fee award. And one final thing is the focus on the various roles, and in the briefing and again today, the focus on the difference in, for example, the Attorney General appearing at the Board of Medicine and DNR's own lawyer, appearing in the contested case in this case. I mean, in those cases, you're talking about not the agency or the actor. You're talking about that agency's counsel and who happens to be representing the agency as counsel there. It's not like a criminal prosecution. It was a prosecution in the case of Reamer on behalf of the Board of Medicine, based on kind of their framework for how they divvy up the investigatory, the prosecutorial, and the adjudicative functions. If you don't have any further questions, that's all I have. I would urge you to vacate the Court of Appeals decision and affirm the District Court. Thank you.
Thank you, Mr. Thompson. The case is submitted, and we'll now hear the arguments in Iowa Supreme Court Attorney Disciplinary Board versus King.